East Lyme Ad Hoc Short-Term Rental Committee. Welcome everyone, and welcome members. We haven't seen each other in a bit. I'd like to call the meeting to order and recite the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Yes. Sure. Thanks, Paul. Thank you. Okay. All right. Second item on our agenda tonight is public delegations. Anyone here from the public who would like to address the committee? Okay. Anyone? Okay, seeing none, we'll move on to item number 3, which is approval of our minutes from our last meeting of April 8th, 2024. Do I have a motion to approve those minutes?
So moved.
Okay, Gary's moved. Do I have a second?
Second.
Gary here. Seconded. Okay, all those in favor?
Just one
actually,
quick
one
discussion.
Yes. Corrections? Anything? Go ahead.
Ready for me?
Yes, go ahead.
Page 3, where it indicates my comments, on the third paragraph down. We had a little back and forth on the
Yes.
on the issue in the minutes there. Said that I apologize for any offenses, comments about bias might have caused, but I still want to make sure it says, well, still concerned about the item. So,
Okay.
if you don't mind adding that.
That's fine. Yeah, that's fine. Anyone have any thought on that? We're okay? Okay with that correction? So,
Thank you very much.
yeah, so we will, as amended, move to approve the minutes of April 8th, if there aren't any other corrections or comments, thoughts. Okay. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions?
That was not here.
Okay.
Thank you, Madam.
Sure. We have Dan Beachy, 1 abstention. Okay. All right. Item 4 on the agenda is reports of co-chairs. I guess I'll begin and turn it over to Gary, if that's okay.
Sure.
Okay. I'll keep this really brief because I think the guts of this meeting will center on item number 5 on our agenda concerning the recent Supreme Court case and state legislation, which are now in effect. But I just wanted to say that, yes, we've had some development since we last met. Our last meeting was April 8th, as you all know, and for the public's benefit, anyone watching this tape to know, and all of this is on our website, on our webpage for this committee. But we completed a status report in April. It was presented to the Board of Selectmen, and because we knew that the WIBI decision, which we understood to be important as concerns our work here, was not to be decided until the summer, we decided to take a bit of a pause. And so we've taken our pause, and the decision came out a few weeks ago, and here we are meeting. So the WIBI decision was a major development in the time since we've last met. Another important development is the enactment of Public Act 24-143, referenced in the agenda, and that of course concerns the, it allows municipalities to enact ordinances to register and to regulate short-term rentals. So something very new, and we had mentioned that in our report that we would be following it, and sure enough, follow among other pieces of legislation that did not pass, but that one did. So, and that happened subsequent to our report. Another development to keep in mind, although less directly relevant to our work, is, I think, the enactment recently in the town of the Fair Rent Commission. We can discuss this in greater length in a different, since it's not really an agenda item, but I just wanted to point out that under the terms of the ordinance, the provisions within the ordinance, short-term rentals are exempt. So, I think there are perhaps questions about how long-term effects of that, if that's something that we've been thinking about, market analyses, as we try to make final recommendations. So something just to keep in the back of your head that that's a piece of local legislation that may have some long-term effects. Otherwise, Paul, you had alerted me to the Borough of Fenwick getting their short-term rental zoning regulations. They had amended them finally through. There were some legal challenges. The one in particular that went to the Connecticut Supreme Court at the same time Wibby was being decided, concerned appropriate notice when their zoning committee met to amend their regulations on short-term rentals. So I actually, Paul had sent me some information, and so I made a little packet of the Fenwick. This again is for a later discussion, but while I'm just trying to bring us all up to date on things that happened while we were not meeting officially. Okay, perfect. This is here, I think. And then Brooke will need one, and one for Mr. Zamarka. So we'll do that. Okay. And Brooke, we'll have this as part of tonight's record, and I'll put on our record. So something to keep in mind about these, and I had a little email exchange with Paul. It's just that, yes, interesting, this development. It's more, the Supreme Court case was not substantive. It wasn't about the substance of these. It was just about the fact that notice was appropriate and these amendments could flow through. But very much, when you read through this, you'll see that, Fenwick's, has in some ways a similar, setup to some of our beach communities, but to some extent different. There are 67 summer residences and 14 year-round households there. So a little bit different than many of our communities. But just giving you an idea that what was adopted there was very unique to their situation. Something we've been trying to tune into is how to address as many needs as possible. So keep that in mind. And I think the other item, since last we met, is Greg came up with a proposal. Greg, our member here, and I'll pass this along to everyone. I think he emailed, but in the event he hasn't, that you haven't seen it, and again, we'll have this as part of tonight's record as well. So this kind of brings everyone up to date with things that have been going on. And yes, I had my appendix removed. Seriously, I did during this time. So I know, I thank you all for those that knew about it, for your well wishes. And ruptured appendix, but along with the Wibby decision, so.
Thanks for scheduling that around our meetings.
Right, I dialed it up that way, that it would work out.
Did Wibby cause the...
Maybe when I read it, I was so in shock, my appendix ruptured. Anyway, so that's my report to bring everyone up to speed. And do you have something for Tim?
I don't have a lot to say. We have this decision. I think we have a lot of work ahead of us. I don't think we should think that the the bulk of our work is behind us. So we will be here for a while to figure out how WIBI applies, and what we need to do to go forward.
I'll make one follow-up comment to that. That is that, so in looking for media, coverage of the decision and thoughts and local organizations, so I couldn't find anything on CCM's site. Didn't really speak to anyone there. I spoke with Betsy Gara, who's at Connecticut Council of Small Towns, and she's hoping to do some kind of a webinar on the decision, and perhaps also covering the state legislation that has been passed. I contacted the Connecticut Federation of Planning and Zoning Agencies. Same thing, considering these two major developments, will you be doing anything? They got back to me and said they'll get back to me. So I think they might put together something. They had presented a good program last spring, where the attorney for Mr. Wibby actually was one of the guest speakers. So I imagine there'll be some follow-up. So we keep abreast of that. But otherwise, I think we can move on to item 5 on the agenda. And for those that don't have an agenda in front of them, this item is a discussion of developments following the status report, in particular this Public Act 24-143, that's in your packet, and the Wibby decision. So I'll start with this Public Act, and also Attorney Zamarka is here this evening. So in the midst of our discussion, certainly if we have questions, we can stop and ask those, or ask them all at one time, whatever works. But in your packets, on page 11 of that document, and I think I have a little arrow there to where it is. So that's what's in front of us, and I don't know, thoughts about it before I speak anymore. Anyone have any feeling about it, having, we had many discussions in the months that leading up to our report about ordinance versus zoning as an approach. And then there you go, the state of Connecticut enacts this legislation. And I'll make one comment that it's not particularly detailed. So, but it does allow for licensing, and it does allow for regulating operation and use. And it does allow for the hiring of consultants.
Madam Chair, would it make sense to get the attorney's opinion before we weigh in, or do you think it's?
Yeah, I just wanted to kind of survey everyone. If you even if you had an immediate question, we could do that, or Mark, if you want to just summarize or give us your feeling about it.
Sure.
Yeah, that's great. Okay.
Good evening, folks. Mark Zamarka, Town Attorney's Office. It's been a while. So before we get into Wibby, it might be a good idea to just remember how it is we got there, or not us, but the case. Mr. Wibby owned a single-family dwelling in the Pine Orchard Association that he rented on a short-term basis, which was a permitted use under the then in effect 1994 association zoning regs. The association amended those regulations in 2018 to prohibit short-term rentals. Mr. Wibby continued to use his property as a short-term rental, claiming that since it was permitted under the 1994 regs, under the amendments, it was now a pre-existing non-conforming use. The association issued a cease and desist. Mr. Wibby appealed to the trial court, and the court held that the ZBA improperly upheld the cease and desist. The trial court held that there was nothing in the 1994 regulations that precluded short-term rentals, and that his use of the property was consistent with the definition of a single-family dwelling. The association then appealed to the appellate court. Now, I know we've gone over the appellate court decision a few times. The findings of note are, first, that the appellate court found an undisputable bundle of rights of property owners, one of which is the right to rent one's property. The appellate court also found that there was nothing in those 1994 regulations that a single-family dwelling had to be owner-occupied, and they did not impose a minimum time length or occupancy requirement for the use of a single-family dwelling. They held that in the absence of any clear language in the regulations restricting renting as a permitted use, they were not going to impose such a restriction, that if the people who drafted the regulations in 1994 wanted to do so, they certainly could have. The other thing of note with the appellate court decision is that the appellate court also found that because there was a sign regulation in the association regs that allowed the placement of a sign advertising a residence for rent, that was an acknowledgement by the town and the zoning commission that renting residential properties was a permitted use. Since there was nothing in the regulations that put a temporal or time restriction on that right to rent the property, one of those undisputable rights, the appellate court was not going to do that for them. Also, we need to note that East Lyme has a sign regulation that is very, very similar to that in Pine Orchard. Pine Orchard then appealed to the appellate court, and as we saw, the opinion came down at the end of July. The Supreme Court, as it is wont to do, limited its decision to the narrowest question possible, and that was whether short-term rentals of residential property were permissible under the 1994 zoning regulations. Pardon me. They, of course, affirmed the appellate court. Now, both sides in Wibby agreed that long-term rentals of residential property were permitted under the zoning regulations. But the Supreme Court disagreed with the association that the 1994 regulations did not permit the short-term rental of residential property. They adopted the same reasoning the appellate court did, that if there was no clear distinction in the zoning regulations and nothing that clearly prohibited the short-term rental of residential property, then they were not going to do so. They also adopted the appellate court's reasoning regarding the sign regulation, and that was an acknowledgement that leasing residential property was allowed. Now, a lot of the decision centered on, as you saw, definitions of home and residence. The association argued that both of those define a place where a person lives with some degree of permanency, and there was a lot of discussion on that. Now, the Supreme Court disagreed. They found that those terms do not necessarily connote a particular length of occupancy, and that the regulations, as we saw, did not include any sort of time limit or time restriction on the rent, on leasing property, pardon me, and that home and residence could both reasonably be interpreted to mean a structure designed for use as a house or dwelling regardless of the length of occupancy. And again, the East Lyme regulations define home and residence and family very similar to that in the Pine Orchard regulations. So essentially, they upheld the appellate court ruling that since the regulations allowed single-family dwellings to be rented, there was no basis for any type of limitation on how long that rental could be. So, where do we stand? The Supreme Court also upheld the appellate court decision, including the undisputable right to rent one's property. And if the zoning regulations, as ours do, allow signs advertising the leasing of residential property, then that is an acknowledgement that renting residential property in this town is a permitted use. And those signs are allowed anywhere where there is residential property in this town. Because our regulations are on what we call all fours, I know a couple people up there will understand what that means. With Wibby, as far as the sign regulations go, the rental of property, the renting of residential property in the town of East Lyme is a permitted use. Similarly, the town of East Lyme does not distinguish between short-term, long-term, or put any kind of occupancy or residency or leasing limitation on residential property. What it means is short-term rentals are allowed in East Lyme, and cannot be prohibited or restricted under the current zoning scheme. Now, the decision did leave the door open a crack, if you noticed. The appellate court, the Supreme Court noted at the end that a commission or a town is free to adopt regulations that permit only long-term rentals in order to promote stability, a sense of community, similarly to what Pine Orchard did in 2018. But that must be specific in the intent in the regulation, that rentals are allowed for only a certain time period. Now, that raises another issue for us here. Pre-existing non-conforming uses. A quick recap of those. In zoning, if something was allowed prior to the enactment or the amendment of a zoning regulation, and that amendment or enactment of a regulation then disallowed that use, any use that was legal prior to the regulations going into effect is still legal after the regulations. It's a form of grandfathering, is what it comes down to. As we know, there are many, many single-family residences in the town that are rented on a short-term basis. Any of those owners, any of those property owners, if the Board of Selectmen decided to enact an ordinance somehow prohibiting or in some way restricting short-term rentals, they would have the right to challenge and would likely win to continue their use as a short-term rental. That's definitely something to keep in mind. Now, the Supreme Court did not rule on whether or not Wibby's use was an allowed pre-existing non-conforming use. They referred that back, or they upheld the appellate court, which kicked it back to the trial court. So we will see what happens with that. But the big takeaway is, as it stands right now, under the current zoning scheme, short-term rentals are allowed in East Lyme, and they cannot be prohibited or restricted. Now, as the chair noted, there's also PA 24-143, Section 7, which says that a town may, by vote of its legislative body, the Board of Selectmen, they may adopt an ordinance that requires short-term rentals to be licensed and regulates the operation and use of short-term rentals. Now, of course, what does it mean to regulate the operation and use of a short-term rental? That's the question. That's the question. There's no judicial guidance that I'm aware of at this point, since Wibby is not even a month old yet. I'm sure there will be test cases coming. However, we do know that there are certain things that we can't do now that Wibby is in effect. Can't do anything that interferes, and prohibits or restricts an owner's use of a single-family dwelling as a short-term residence, or short-term rental, Now, I know early on, and I'm sure these have probably gone by the wayside, but you'll have to forgive me, it's been a while since I've been to a meeting. Early on, there was talk of a lottery or limiting short-term rentals to certain zoning districts. Neither one of those would be allowed under Wibby. There's just no way those would not withstand any type of challenge at this point. For right now, and I don't know if everyone's had a chance to look at Mr. McIntyre's proposal, but there are certainly some good ideas in it. We would recommend minimal oversight at this point. We know that they can't be prohibited or restricted in any way. We do know that other towns, at least so far, have adopted regulations, ordinances where they need to be licensed, that there are fees, certain inspections, things like that. Unless we want to become a test case, we may want to be careful what we would recommend to the Board of Selectmen that might be considered overreaching at this point. I know the committee has been looking at several other towns. That's certainly areas for discussion, and what, if any, type of oversight or regulation would be recommended to the Board of Selectmen. A couple things to think about. As we noted in the beginning, and this is consistent actually with the new Public Act, it is our strong recommendation that anything this committee decides to recommend to the Board of Selectmen be in the form of an ordinance and not a zoning regulation. That's now, as of October 1st, will be codified in the new Public Act. And also we have to remember that there are 3 beach communities in this town with their own zoning, and the amendment to the East Lyme zoning regulations would not apply to those 3 areas. Another thing to think about is enforcement. Whatever oversight the committee may decide to recommend will have to be overseen by some body, some entity, some person, some department within the town. That's always something to keep in mind, budgetary concerns, things like that. And you know, since it is an ordinance, the final decision on that will end up being made by the Board of Selectmen, unless a separate body is appointed, and that also, as we've seen with the Fair Rent Commission, leads to its own issues. So, to put a bow on it, for lack of a better term for now, WIBI tells us that we cannot prohibit short-term rentals in the town of East Lyme. The town certainly can, and the WIBI decision allows a town to enact an ordinance allowing only long-term rentals of residential properties. That has to be spelled out specifically and distinctly in any ordinance or regulation. And the thing to keep in mind is anyone who has been renting their home or their property on a short-term basis before something like that goes into effect will be allowed to do so after.
Can we ask questions?
Yes, sure, we can begin. We could begin this way, perhaps. Yeah, go ahead.
I might be slower than the rest here, but when you said that some of the things that were in this draft, are you saying that a permit or a fee or a safety inspection could be considered restricting the use of someone's?
No, because the person is still being allowed to use the property as a short-term rental. Again, it's a good question, and frankly, we don't know right now what regulating the operation and use of a short-term rental is.
Okay, I thought you were cautioning us that some of the things are already built into this.
That's a very good question.
Okay.
That's a very good question, and that's something that this committee is going to have to discuss.
I missed, you may have said this, they say we can regulate long-term. Is there a cutoff point where it's long-term versus short-term?
Again, that would have to be something that would be considered in the ordinance.
So the state didn't set that up. What is
No,
long-term?
no,
What is short-term?
what the Supreme Court said at the end of the decision, and I don't have the exact verbiage in front of me here, but basically what they said is that a town can allow only long-term rentals or prohibit short-term rentals so long as there is something clear and precise and specific in whatever that may be, an ordinance or a regulation. One of the issues with WIBI is that essentially the regulations via the sign regulation said, yep, you can rent a residence. Nothing else. You can rent it for X number of days. It can't be rented for more than X number of days, anything like that, just boom. The leasing, renting of residential properties is allowed. Therefore, the courts are not going to step in and say, nope, it can only be for this long or that long.
Okay. And let me do one more, then I'll let other people talk, I guess. This grandfather thing, how to prove that you have been renting, how is that done?
Now, that would be up to the individual owner.
Okay.
Generally, a pre-existing non-conforming use is shown by testimony. I'm sure the owner, now people rent through Airbnb, Vrbo. I'm sure all they'd have to do is show a contract, show some rental receipts, and whatever it may be.
Does that open those people up to, if they haven't been paying the state taxes, what is it, 15%?
Yes.
And haven't been, is there like a personal property tax that would change if you're renting something locally or no? Would it open them up to having to pay back taxes?
I honestly don't know.
Yeah, I would assume on that room occupancy tax, because they don't pay a different tax because a different property tax in the municipality because they are a short-term rental. They may pay a personal property tax if the town assessor's been alerted to their existence.
Okay,
Okay.
okay, thank you. Appreciate your answers.
Yeah, we can come back to Dan if you, yeah. So, Gary, did you want to ask?
Why don't you go?
No, it's been a while since we met. Wasn't the cutoff 30 days between short-term and long-term?
At least under the state definition, which is
Yeah.
the general definition.
Wasn't that a definition in the state tax code or something like that, if I recall?
Yes,
Yeah.
and elsewhere. Right, so, yeah, so that, over 30 days would, yeah, that's where you are with the long term.
Does the pre-existing nonconformance rule apply to ordinances as well as zoning
Yes.
regulations?
Yes.
And because of this ruling, would it make sense for us to stop discriminating between long-term rental and short-term rental and just calling it rental?
What do you mean distinguishing between the
Not
two?
distinguished.
Well, I guess it depends. That's more a matter for the committee to decide on. I mean, as it stands right now, if you are allowed to rent property, you're allowed to rent property. It can be for a day, 2 days, a year, 2 years.
Right. So our existing idea was, since it's not permitted, it's not allowed.
Right.
But
that-
that's no
yes.
longer operable.
No. Wibby blew that out of the water.
Okay.
So, go ahead.
Go ahead, Paul.
So, thank you, Madam Chair. So the sign regulation is really the key to this whole thing, because if the zoning regulations are permissive, then neither long-term academic or short-term rentals are mentioned in the zoning regulations specifically. The signs that are allowed forego all that, and they say it has been a permitted use because the signs were a permitted use.
Correct. Correct.
So if we were gonna, as we've discussed as a committee, think about suggesting the adjustment of the zoning regulation and the town ordinances at the same time, we would not need to define, to Gary's point, short-term rentals as an option. We could simply add in definitions of dwelling rentals, and whatever that verbiage turned out to be, and in the section, starting with section 3 of the zoning regulations, that rural 120, rural 80, rural 40, etc., they all list accessory uses, and so we could simply add rentals of a single-family home, or rentals of some item, or rentals of a dwelling would be an accessory use to the single-family home.
I don't know that that would necessarily be an accessory use, because an accessory use is something that is customarily and ordinarily attached to the primary use. The appellate court and the Supreme Court both basically said that the right to rent property is an indisputable right of ownership, so I would say that that is a primary use of the property. So I don't think classifying it as an accessory use would be proper.
I only thought that because home business is an accessory use,
Right.
and that doesn't seem to be a priority either, but.
Right.
But anyway,
But-
could we use our own line, a separate line that says dwelling rentals would be allowed as permitted in the zoning regulations? And it would-
We could. So to get back to Mr. Beachy's point, I did find the verbiage in the opinion. So it's on the last page of the majority. It says, although zoning authorities are free to adopt regulations that permit only long-term rentals in an effort to promote stability and a sense of community within a single-family residential zone, there must be specific evidence of such an intent. I did a little ellipse there, but I was...
Which page is that on?
So it's
That
page
is a
19.
good question. I don't have the same kind of
It's
copy you
page
do. I have an
19.
advanced copy.
For us, it's
yeah,
page
in-
19.
Yeah,
Yeah.
it's the end of the majority decision. So if there is going to be some effort to say we are allowing only long-term rentals, be that over 30 days, 60 days, whatever it may be, if it's in an ordinance, if it's in a regulation, in the definition section for the zoning regulation, certainly, but based on the language in here, to make sure that there is a specific intent that can be pointed to, it would have to be spelled out, I would say, perhaps in its own separate ordinance, or, taking a look at the overall zoning scheme, seeing.
Yeah, if I may,
Sure.
my thinking was that we would allow it as a permitted use in the zoning regulation under rentals, dwelling rentals. Not short-term, not academic, not long-term. Dwelling rentals are allowed as a use, which they are, but it's not, says so.
Mhm.
And then we could adopt an ordinance, I think yours goes a little bit too far, but some type of ordinance that.
I knew you'd say that.
But well, well, we can talk about it. It seems redundant in a lot of ways, because there's already laws on the books. We just make the chief go to work, that's all.
Yeah, because he hasn't had anything.
But if we recommended some ordinance that was specific to not regulation. Registration, thank you.
Yeah.
And some type of counting.
Yeah, and you raise an excellent point, because we do have sort of the bifurcated system here. Maybe we'd have to go and look at the zoning regulations. And again, this is just spitballing here. A regulation, or an ordinance, pardon me, may be enough, because remember, anything we do to the zoning regs isn't going to apply to the 3 beach communities with their own zoning. So I understand the impulse to do that. I'm not sure that that's necessarily the best way to go about it, because we'd still have that gap.
I think you're gonna have more of a problem with long-term rentals with this decision than you are with short-term rentals. to
Could
be
be.
honest with you. I think
Could be.
there's
It's
quite
a
a
whole
bit.
new world.
Yeah, quite a bit more. So, all right, thank you very much. Thank you.
Yeah, just for my own sake, in the Connecticut regulation 5474 that was just approved recently, they talk about short-term rentals are defined as in section 47A-1. Do you know what the specifics of that definition are?
47A-1, if memory serves, I don't know it off the top of my head. Mr. McIntyre, I do believe that is the landlord-tenant statute, but I can certainly get that for you.
I'm sorry.
I believe
So,
I believe that's the landlord-tenant statute. I'm not sure.
I'm not sure exactly where it's buried either, but it's a definition of dwelling unit. That means any house or building, portion thereof, which is occupied, designed to be occupied, or is rented, leased, or hired out to be occupied as a home residence of one or more persons.
It's the landlord-tenant statute.
Yes,
Yeah,
okay.
it's the definition found in the landlord-tenant
Yes,
statute.
okay.
Thank you.
And then
Go ahead.
one more.
Yeah, sure.
So as this decision and the conversation we're just having relates to the Public Act, does it negate some of the Public Act's intent or legislative intent, or some of the
No,
language?
I don't believe so. I think it's sort of, I think the Public Act sort of brings to light what we've been saying from the start, that if anything's going to be done, the Public Act allows the legislative body to adopt an ordinance. It doesn't restrict any zoning commission from amending their regulations. I think, if I can put myself in the shoes, it seems like this was done as a way to give towns a little bit more of a hand on the wheel in terms of how to try to oversee short-term rentals.
And is this a may in the regulations or a shall?
It's a may.
Okay.
It's a may.
Just before we have more questions, I just wanted to point out something about the Public Act and a couple of comments. They were quoted in those media pieces that you have, but it was Attorney Mahaney, who was for Mr., along with Attorney Pillacy, who represented Mr. Wibby, and he's quoted in one of the articles as saying he thinks that this act is actually unconstitutional. And he kind of joked about how, because Wibby took 4 years of his life there to litigate, he's not going to go after it, but he put it out there that that it definitely challenges the basic idea that land use is regulated by way of zoning versus ordinance. So, it's just something out there, and not to panic, but I think that that could very well be on the horizon. That would be one of the charges leveled against a town ordinance somewhere, for starters. That if you want to regulate short-term rentals at all, you got to do it by zoning and not an ordinance. So that's something to I guess.
That's a good point, and I'm
just-
sure there will be all manner of
Of
challenges
challenges.
to the Public
I
Act,
know.
to WIBI, to towns trying to see what they can and cannot do in terms of regulating short-term rentals.
So, if I may, besides keeping the legal practices vibrant with this regulation, if Whitby is challenged and somebody wins, who overrides it? The Supreme Court itself? They
Yeah,
just say, oh,
yeah.
we made a mistake? Or-
Well, so
or we go to
the
the
Supreme
dissenting
Court
opinion?
generally does not overturn itself.
Yeah.
But what I would foresee is towns saying, you can only have 4 people in a home or something like that. Just it's sort of like, and this is a bad analogy, but it's the only one that comes to mind. When Roe was first decided, then there were all these other cases kind of chipping away at the edges of it, and I would foresee something like that coming up here. Like, okay, you said WIBI says we can't prohibit, but we can't. But the regulation says we can regulate. So what does regulate mean?
I also, if I could say, I also envision just towns differentiating their zoning regulations to what the 1994 regulations look like. So, for example, if I were arguing for the town, I'd say, well, we haven't, our zoning regulations are permissive, traditional thinking on that, and that's supported, that it doesn't deal with short-term rentals is supported by the fact that we have many other provisions in our zoning regulations that regulate lodging, whether it's a bed and breakfast, an inn, a motel, a hotel. So we have all this other stuff in our regulations, but we don't talk about long-term, and we don't talk about short-term rentals. So,
A thing to keep in mind too, though, WIBI and the Supreme Court decision focused on single-family dwellings.
right.
It did not go beyond that into more
Right.
commercial, multi-unit. So, but again, there's all
Yes.
sorts of challenges that may and undoubtedly will come.
Go ahead,
I
Ann.
don't know, the Fenwick regulations, were those done before or after?
This is the first I've seen them, so I have
I
not
was
even
just
had a
curious.
chance to
They
look
seem
at
to be pretty, like, they can only be used for family use, not for party celebrations. I mean, they get pretty detailed in there.
I did take a quick glance and saw that. Yeah, I just went, okay, we're talking about Fenwick. But again,
I don't think
that falls under the umbrella of,
Regulation.
yeah.
I don't
What
think
does-
they ruled on those specifics. I think they ruled on
The notice.
the notice.
Oh,
And then
Yes.
Again,
the
I
notice
yes.
thing winning, then they said, well, let's put all this stuff in there, which
Oh, I see.
now I think becomes moot with this Supreme Court thing.
Okay, again,
So
I
I think
have
that-
not seen the Fenwick case yet,
Yeah.
so I wouldn't,
That's how I read that, yeah.
I wouldn't presume to comment on it.
So, Mark, for zoning, for beach communities, such as Black Point, and our other two, Crescent Beach and Giant's Neck, that have their own zoning. So in other words, if this is the interpretation of WIBI that would generally apply, then they are in the same boat as the town, presumably, because they're considered.
It's going to depend on what each individual zoning regulations say. The East Lyme regulations happen to be in the same circumstance as that of Pine Orchard, where it counted, with the sign regulation, with the fact that the definitions of residence and dwelling and family are all very, very similar. Had there been something in the East Lyme regulations before that said, you know, you can only rent property for a maximum of 1 year, but not less than 1 week, something like that, it's possible that WIBI might not apply. But in our case, our case, again, is, I hate to use the term, we used to do this in law school, but East Lyme is very much on all fours, all four corners of the document with the Pine Orchard regulations and the WIBI case.
And with respect to the sign regulation within our zoning regulations, do you have a certain citation within that you primarily rely on? Because there's quite a bit on signage.
It's in section 18,
Yes.
Are the sign regulations. I did have this 18 . I can find it for you. I don't have it right off the top of my head, but I'll be glad to give it to you.
We'll take a look at that a little more
I don't have it off the top of
closely.
my head, sorry.
Okay. Definitely, I guess the beach associations that do not have not written anything yet. Well, let's say, so for example, Crescent Beach has not addressed short-term rentals. So I guess their silence is sort of like our silence, right? I mean, just generalizing here, and for you guys perhaps as well.
Well, we are following Black Point, who just renovated
Right,
their
they
regulations. So we've had one public hearing, Giants Neck Beach Association.
Okay.
We've had one public hearing on the zoning revisions, where in those revisions, it does allow short-term rentals specifically as a permitted use in there. So if there's another public hearing, and then the commission will decide. But that's how that commission has decided to do it. And so they've spelled out a definition and then used it as a permitted use. So.
Black Point just does it, you know, limits all rentals to a minimum of 7 days.
Is that new, though? Isn't that
No,
new?
that's been for years.
Oh, that's been for you, okay.
Yes.
Mark, I have a question. So, the East Lyme zoning regs have a provision where it does not allow tourist homes. The history of tourist homes is probably the closest thing we have to a precursor of short-term rentals, which is then different outside the four corners of the Branford zoning regs. So that could be a, because the history of tourist homes is almost identical to what has become known as a short-term rental. I think it's in section 20.3.
Okay.
So that's how I read it. It's in this section on home occupations. On home occupation. It allows.
Okay. Is this under the special permit regs?
No.
Okay.
I saw it just on the home occupations.
Okay.
And it lists, you know, a various number of occupations that can be used in the home, and then it says no, if I recall correctly, no barber shops, no tourist homes, and maybe 2 or 3 other things. So my reading of it, that's the distinguishing feature from the, not that I've read the Branford zoning regs, but at least that what the Supreme Court mentioned.
Interesting. I'll have to take a look at that.
Right, so I bring that up.
Sure.
And my second question,
And I'm sorry, what was the, Mr. Chicago, what was
believe
the
it's-
regulation?
zoning regs 20.3.
20.3, okay. Okay, thank you.
And my other point or question, you seem to have said that East Lyme can still, and the court said this also, can still um, create an ordinance or pass an ordinance that precludes short-term rentals.
Right,
That then we would get involved with the grandfathering issue, I presume.
correct,
Okay.
correct. Yeah.
But that's a way, if the town people wanted to control the number of short-term rentals.
Right. You essentially, if that was something that the town chose to do, you would be in effect blocking the number of short-term rentals at anyone who had been doing it up until that point.
Right.
They would be allowed to continue, and then depending on how the ordinance was set up and the inevitable legal challenges, there could conceivably be no long-term rentals after that.
But, and if there's any...
Short-term, pardon me, I'm sorry.
Right, I get you. If there's any substance to the tourist home issue, that could be a way to eliminate the pre-existing use argument.
That is entirely possible, Mr. Chicello. I'm not familiar with that section, but I will be glad to take a look and report back. I will be glad to do that. Sure.
One other point just came to mind about Whibby. It was very interesting that both sides basically conceded that long-term rentals were permitted under those 1994 regulations. So you're starting from you're already starting from that point. They weren't arguing that. The defendants did not argue that point. So to me, not to get in the weeds, but it just seems like there were certain of these things that, that the court could conveniently, draw from, while probably trying to protect the rights of homeowners to rent their property. I have to tell you, reading the minority decision, it was kind of refreshing because, especially as concerns definitions, I think that's where most people really probably disagree with the majority, reading about what is a home and what is a residence, and just a little, a bit too far, but I almost think they could have come to their decision in a different way, maybe not going through that analysis, but in any event, we are stuck with it, unless there's some U.S. Supreme Court,
I don't know of anything that would grant the right to get federal appeal status to
Right.
this. So.
Yeah, I don't think that's happening. I didn't think so from the get-go. Any other questions for Mr. Zamarka right now?
I just have a comment. We seem to be talking about long-term rentals. Our mission or charge in this little commission is to talk about short-term rentals. I think we're going way beyond. I think it's a red herring for us to even get involved in long-term rentals. We took no evidence on long-term rentals. There's been no hearings. It's not what we're supposed to be dealing with. So my position would be that that is not anything that we're supposed to make any recommendation on, simply because there's no evidence. That's not our charge, and we heard nothing about it.
And that is completely up to the committee's purview.
To me, we're going to have to deal with it at least in one place, as where does long-term start, or where does short-term end and long-term begin?
I don't know if that's for us or the Board of Selectmen. But
No,
I'm saying
well,
we have to provide a...
Yeah, right.
Right.
I got you.
And
That's the
as it
only
stands
part of
right now,
long-term
there
I
is no
think we
dividing
would
line.
do. Where does it start?
And again, the only reason I brought that up is because the majority pointed out that there was
100%.
still, the door was still a little bit ajar, so.
Right.
Thank you.
All right,
Thank you.
thanks, Mark. Okay. So we can, any other thoughts about, before we jump into number 6, which is kind of will be sort of an outgrowth of our discussion in agenda item 5, which number 6 is our trying to determine what our outstanding issues and questions are, so that we can get to the point that we, that we are ready to make some final recommendations. But we're certainly not there yet. So any other discussion, any other thoughts about the legislation, impressions you had, concerns that you have?
I think the question that we need to answer as a town is the first question in the first meeting that we had, set forth by Ann Santoro, that do we want to have short-term rentals in town? Are they a positive thing or not? I still think that's an issue. That's the first issue that we need to answer.
So even for
So you're saying,
us,
is it a problem?
Is it a problem? Do we foresee it being a problem? Can it be a problem? Yes. But that's the first question that was presented by Ann, and I still believe it's the most relevant question that we need to get by first, and then we can get into all the other stuff. But that's the more difficult question.
yeah, I tend to agree with you there, and I think that even though we're making recommendations, and we're not the ones deciding the fate of the town, but we're making recommendations, that is the starting point. And if you go back to the report on page 14 of the report, if you don't have it in front of you, just maybe make a note. In section 8 of that, where we talk about adopting regulations, this is the process in the second paragraph on page 14. And I'll just read this into the record, because I think this kind of is this is the process. That the town is considering a policy to specifically allow and regulate short-term rentals, it has much to weigh. It must first determine that expressly banning these rentals or relying on our current legal framework are not desirable approaches to addressing concerns presented. It would then need to decide where these rentals might be allowed, what might be regulated, the preferred legal methods of regulation, as well as how the regulations may be enforced and at what cost. The only change there might be zoning location if Mr. Zamarka's analysis, is on point there about WIBI. It's very broad, but generally, yes. I mean, that's the starting point, and it should, I guess, if nothing else, that's a point we have to emphasize to the Board of Selectmen, that you have to make some decision as to the desirability, of short-term rentals. Is it something you want, everywhere in every situation, and you would like to regulate them, but it's something that you don't want to really curtail. You want to flourish, so you have to think about that. Similarly, if we on page 11. I went back, I have to tell you, I went back and read the report again as I was trying to gear up for, starting our committee work again. And I looked at page 11, section 6, and it's about the different beach communities. And Paul has often talked about this, but the differing circumstances of each beach community highlights the challenge of adopting policy to address a variety of needs and a variety of preferences. So we still have that reality. We have the looming and now looming WIBI decision. I think it's going to be difficult to 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 come to some decisions and some recommendations that hit all the points we wish to hit, but I guess we'll do the best we can. So I'll move on to section 6, or item number 6 on the agenda, for outstanding questions. And one that I still have, but it might be moot, looking at Wibby, is with these beach communities that do not have the power, don't have zoning authority. They don't have the power to regulate by way of zoning, but they can adopt and have adopted bylaws. What's their authority? That was a question I had pre-Wibby, and I still sort of have it. Because in my mind, I'm still thinking about Pine Grove, where it's been articulated by the president there, Ms. Jet Harris, it's in the report, that there's no desire there to have short-term rentals. So how do we address that? What's the vehicle by which we address that? And I guess my point is, I'm just not clear about the rights of some of these communities that don't have zoning authority to otherwise, enact bylaws or ordinances or do anything else. So I think that's a legal question that we should still try to answer.
What's their, what is it, what kind of entity is that?
So it's still, it still seems to be some sort of a special act community.
Oh, okay.
But that word is used a lot, even where
Special act?
these associations don't seem to have zoning authority.
I mean, it seems like if they don't have zoning laws, it's just another neighborhood, and they're subject to the.
But they're incorporated.
They're incorporated.
Yes, by
I mean,
special
that's what
special
Mark-
act. Right, by special act of the state.
Fish out of water. On this.
Yeah, that's like not my line of country. So, but that would be good to understand. It's like the easier cases are the ones where you have your ability to zone.
Wouldn't you go to the last page of the Wibby decision to speak to that, where it says zoning authorities are free to adopt regulations that permit only long-term rentals in an effort to promote stability and a sense of community within a single-family residential zone. So that doesn't mean you will disallow it for the entire community, but you pick one of the 6 or so residential zones that are outlined in the zoning, and if Pine Grove fell into one of those easy enough and the rest of the other people didn't object, you might be able to include them there. But I think to your point, sir, that I think we know the answer to the question you're bringing up. Everybody that came and spoke before us, with the exception of 1 or 2, did not want to eliminate short-term rentals. Even those who were opposed, they said, well, we don't want to stop it, we just want it quiet in our neighborhood. Even the gentleman to my left said that and he's as aggrieved as anybody in the community about what's going on. So
I look more for the quality than the quantity of testimony. So your point is taken, but
So who do you determine has better quality in testimony?
Certainly my quality is as good as anybody.
I think, well, you didn't testify, sir, you're on the commission. So,
It was difficult with, we had the 2 public hearings, we had delegations at just about every meeting. I mean, we had delegations offered at every meeting, and many people spoke. But I think when Gary had done that analysis, and this is in the report as well, there's that little bit of lopsidedness where, there were more folks who are owners of short-term rentals who did testify, who did, give some information. So
Well, I
there's
think
that little bit
owners
of
were
that.
notified to come, so I think that made a difference a little bit.
Yeah. So I'm not sure the mechanics of all that. And this is just the reality of public hearings. You can't, you hope that and if you offer multiple of them, that does help. It's just the reality that many times people who should speak up don't speak up. So, but we have to deal with what's in front of us. We can't make it up. To your point, Paul.
Yeah, and the former chief came and spoke, said there were very isolated incidences of noise and community disruption, to his knowledge. And that's mostly because people didn't report excessive noise or parking regulations that they thought might be able to be enforced because they just didn't either want to get involved or whatever the reason. But if you don't have a lot of these people saying that it's a big problem, then I don't think we should offer, in some cases, a solution that's looking for a problem. You know, I think
We could come back in 20 years. You know, the rest of there's many, many, many cities and towns all over the country and world that they really have a problem with these things. So we can come back in 10 years and argue it again, see what happens. That's all.
Yeah, I'm not discounting the people that do want them, but you don't hear from a lot of people that wanted to buy permanent homes here, or rent permanently because they're not available because they are being purchased for short-term rentals. So I think it does take housing off the market for people that would like to be permanent residents. So just a point.
Yeah. Well, I think the report did a good job of showing the pros and the cons generally, and then specifically looking at and analyzing the actual testimony that we got. So I think that was good. So any other questions? So, next steps, questions. What do we have outstanding that will help move the ball?
I've got a question.
Yes, John.
Since we have the police chief here,
Yes.
no matter what we do, or it even exists today, what kind of enforcement? One of the big issues is noise. So if they were to get a noise meter, maybe they have one now, I don't know. No, but if we were to get one,
You can come up, Mike.
and then how would what enforcement would take place? And then also, follow-up question to that is, in these beach communities, each beach community has some of their own ordinances or laws or zoning. And, where does the police department, for example, in Black Point, we have no off-street parking, or no on-street parking, I should say. And, does East Lyme Police Department enforce those rules? Will they enforce, if we put a ordinance in for noise, is your police department going to enforce our noise ordinance, or does it, have to be a East Lyme regulation?
So like a good example of that is Black Point, right? So they do throughout the summer hire an officer, kind of almost like as a security portion. So down there, we're working for Black Point at that point. Yes, we're East Lyme police officers. Yes, we abide by Connecticut state statute. However, you as an entity are hiring us to be down there to enforcing your regulations there. So while there, yes, the officers will write tickets for going through stop signs, things like that. But when you have your own general bylaws within your association, and we go enforce those, then usually those problems get put into the logbook that the officer has, and then we make contact with you guys, try to enforce the golf carts. Obviously, that's a state statutory thing for age and the items on it based on the town ordinance. But, the parties, the on-street parking, things of that nature that you guys have that you're asking us to enforce, that's, we go in and talk to each member household at that point.
Right, but I mean, you wouldn't be issuing a violation per se.
Correct. Right, because I know Giants Neck Heights right now is kind of going through the same thing. They're looking at revamping some of their bylaws or ordinances down there, and I've got to return a phone call tomorrow because they want to discuss parking issues, right? So some of the on-street parking things.
So if this commission was to adopt a noise ordinance for short-term rentals, just for example, okay, it would, if it was applied town-wide, I guess, then that's something that all the beach communities would have I mean, it seems to be that's one of the biggest issues. And one of the other issues I see also, we keep talking about single family too, but how about the apartment complex? I mean, Airbnb started renting rooms out in a house, or an apartment, renting a room out. You start getting into some really interesting issues. If you have an apartment complex and somebody wants to rent, they have a 3-bedroom, they want to rent a room out, and you got transient people coming in and out constantly, you know, that's gonna be, you know, that's a, and we've highlighted just on one issue here, but it is really more than that.
Right.
You know, I don't know what the answer to that would
Right.
be, especially if you had security codes and everything else.
Right.
You know.
To the,
And we do not have a noise ordinance meter.
I know it.
We don't, Waterford had one years ago, and this is going back, Paul, I think when even you were in office, we were talking about this. It very expensive machine, and every time you go to use it, it's got to be recalibrated, just kind of like our radar and laser units, and we have to prove it's been calibrated, and to the tune of, I think, at least back then, it was $300 prior to using it, $300 after using it, so $600 just to calibrate the unit to go and issue someone a noise ordinance violation. So it was an expense the town didn't want to get into back then. I couldn't even imagine what it is now with the newer equipment. I know we pay for our radar and laser units. The noise thing, we just never, I've been here, working here 23 years. We've just never had any type of tool to do that type of distinct measuring. So when we show up, if it's, I mean, obviously it's unreasonable. It's 11 o'clock at night, music's blaring, there's a huge party
Right.
going. It's unreasonable to all the neighbors. And of course, yes, we affect that. We do have some times within the ordinance as well. So we do enforce those. So the officer's on scene for that now, but.
so how, Mike, how would you make that noise ordinance workable using that? It's like federal standard, and it applies to all the, you know, towns in Connecticut, and they all have the pretty much mirrored that same, like our townwide noise ordinance, they have the same thing where, you know, they expect you to have the noise level meter. So if you're not, how could we make that functional?
It's based off the creating a public disturbance state statute, so it's more of an infraction versus
Okay.
like an on-site or custodial arrest where, you know, the breach of peace type of thing would come in, so we would
Right.
be able to hand off the infraction at that point.
So you're not really using the ordinance per
Correct.
se.
Right,
You're-
so
you're
we-
using state common law, common
Correct.
law or
Yeah.
state statutes, whatever.
Yeah.
Okay. But it would be good just to know if it's, and I think it's deep that actually somehow manages, you know, that whole, because it's sound
Right.
pollution and
Yes.
so forth. But it'd be good to know, like, who's done it and who's used their noise ordinance with the sound level meter. Like, who's done that, and is it still possible? You know, is it within the realm of
We could definitely
possibilities?
look into it for sure.
Okay.
And we do have town tickets, right, for parking.
Yes.
You know, on Main Street, things of that nature. That's something town engineer, a whole bunch of us are collaborating to kind of redo the parking on
Right.
Main Street.
Right.
Yeah, there is a box for other on there, which does give us that avenue to, you know, put in the, you know, ordinance thing, so the parking
Okay.
goes on there. However, the state tickets also have the same thing. There's a schedule in the back
Okay.
where if just throw a random number, if the fine is $95 for the state, then there's a whole formula you can add on that there's an ordinance violation, so the town, in theory, gets only a very, very small percent, right? So say the total ticket comes to like $113, maybe the town gets $3 of that for having to go through that process. So it's not a, you know, there's no money thing here as far as that goes. So there's no revenue stream to come back even to say, hey, this will offset the cost of recalibrating this machine if we were to get something, at least with that old version that I was discussing earlier.
Okay. Okay.
I would think, maybe, like I said, I'll definitely look into it. I would think this day and age with
Yeah.
technology that there's something more reasonable than what used to be, have access to.
Because I've heard the opposite, that these machines are actually now inexpensive.
Yeah,
and
which is probably
readily
where they're at.
available.
I just haven't, we
So
haven't
who
looked into
knows?
it
Yeah.
and
Okay, so
like I said,
so
since
something,
Paul's been in
we should
office
just
for a
satisfy
while.
ourselves that we can use that statute or not, perhaps. Go ahead.
No, I was gonna say the public, at least the public disturbance, common sense is what his officers.
Yes.
Yeah.
I think that makes a big impact too, if there's an issue, whether it be Airbnb or VRBO or just a regular individual parking in
Yes.
the house. So I think that I'm sure we all violate it occasionally, so
Yeah,
so common sense comes into play.
right.
And they do have the statute or ability in egregious situations to deal with it, so I think that's, but people have to call, as Paul said, people have to call. if there, if there is a problem.
Right, and I've, prior to the chief, it would usually throw those complaints down to me to look at, and I can, just by sitting here and doing a quick recollection, 3 separate beach communities, 1 complaint each, and then 5 Scott Road when that house has gone up for kind of going against the Fenwick thing, right? Not to have parties or whatever, and we were getting loud complaints, fireworks, and somebody rented out for a huge party at one point. So there's 4 instances I can think of off, the past 4 years maybe, for these short-term things, because this is obviously a fairly new concept, and hence why I guess you've been formed to kind of to hit this.
Right.
And figure out how to deal with it. But like I said, I haven't been to the other meetings, and I think, you get some people, not everybody, we would love to have as many town folks come to meetings and speak up on issues, but, it ended up not coming down here. And I think that's what it is. It's the combating the short-term 2-3 day things where it just turns into a big party. And for us, it's really the parking and the noise is what we're usually called for.
Right.
In those instances.
All right. Thank you.
Thank you.
Well, before you leave, could I ask a question? And I know you don't know the difference when you show up, whether it's a short-term rental or these are the people that always live there, but this summer, have there been a whole lot of noise complaints, parking? I mean, is there a number that you guys have?
Not off. I could look that up through our RMS system to see if I can find that specifically, but offhand, I can think of Pine Grove was one. I had one down in Crescent Real, actually near McCook's was another one. So there's definitely 2 just in this current year that I can think of off the top of my
So
head.
this summer, you would say that there's from a handful to 2 handfuls?
Yeah.
5 to 10 at most?
10 would be extreme. I can't tell you that
Can't think of
even
that. So
been
maybe
10.
5 is where we're
Right.
at. Okay, thank you.
Okay, thanks, Mike. Thank you. I see Diane, our assessor here. Diane, is there anything that you would like to add? I know we, in the report, we covered the topics of, a taxation and for real estate as well as personal property. And thanks for the information that you provided to the committee. It's very helpful. And you have the real estate situation won't change, but the personal property tax situation could change. Where if we have a list, we could change that. And so
I don't, that subject, I think that
yeah, come on up.
if Airbnbs are gonna be allowed,
Mm-hmm.
if Airbnbs, are allowed, that'd be, and they are obviously, I think that one consideration would be is that people do file a business tax return, business notification like we do on all commercial properties, what our income and expenses are, because I think that the ones that are being actively used, on a full-time basis for an Airbnb, are obviously, could potentially have more value for that piece of real estate than it does for residential. May not, also it may not, but it could. And I think that would be, if it's an excessive situation where somebody's got a, 200 grand NOI or something for $1 million home, obviously it's worth more at that point, and maybe that, that should be considered, why,
So,
in the commercial business, we have to pay more
Yes.
based on our profitability.
so I think
So that's an issue.
Diane can shed light on that because some of that was in the report where we discussed mass valuations for residential property versus commercial. So, for the public's benefit, you could just briefly explain that. That's very helpful.
Okay.
And to John's question.
Diane Vitagliano, Town Assessor. At this point, we have not seen, it has not been proven that the short-term rental properties are making a property more profitable than just a single-family use. If it becomes that that is the case, then, you know, we would love to have that rental information, which we can kind of gather from the internet, and use the income approach on it. But right now, as a single-family property, we don't develop the income approach for those homes. It's mass appraisal, and we value them as single-family properties for the most part.
And that, Diane, I understand, is a statewide practice in Connecticut. I mean, towns in the state of Connecticut follow this same approach as concerns residential property valuation. Okay.
Yes, yep, it's all mass appraisal, and, you know, it's hasn't gotten to the point where the valuation is different.
Okay.
It's because, excuse me, that's obviously, if you don't have the business returns, you would have no knowledge of that, unless you did the research, a lot of research.
Right,
So-
well, we look at every single sale that happens,
Right.
you know, we kind of study them going forward, also. So if you know, a property is purchased by an LLC, you know, for the purposes of short-term rental, then we kind of keep our eyes on it, you know. If there was ample evidence that the income approach would be the way to go for such properties, we might change our methodology in the future, but we're not there yet.
If there was a registration form, if registration became an issue, and there was a registration, that could be a requirement that they would have to file a business, you know, annual return, you know, to the town.
We
But-
don't have that authority within our statutes right now to be able to require that information. So right now, we can require income and expense information
Right.
for any properties that are 6 units and above.
I
We
see.
don't have the statutory framework to require anybody to report to us what their rental income is for anything below the 6 units.
Is that a state statute?
That's state
Okay, so
statute.
at the top,
Yep.
so if we put an ordinance in, we don't have that authority to ask for that then?
Right.
Realistically, then it
We
has
don't
to be a
have any
state
framework.
statute.
That's right. We don't have
Okay.
any legal framework to be able to do that.
Okay. And we don't have a legal framework to ask for that, really,
That's
in
good.
anything we're doing. Hey, well, answer that question, thank you.
Paul, you have a question for Diane?
Thank you. So I have a few single-family homes rented as long-term rentals. They're not 6 units in there. Are you saying?
No, so you do not have to fill out the I&E for them.
So if I don't fill out the I&E by November 1st, isn't there a 25% penalty on my taxes, which?
No, so there's a difference. So there's 2 programs. There's one which is the income and expense form, which is due June 1st. And that's a 10% penalty on the real estate. The other is personal property, and there's a 25% penalty on personal property for failure to file or for filing late. So 2 very different things. So with the short-term rentals or long-term rentals, if a home is being used, I would consider that a business. And if it was solely for the purpose of renting and it was furnished, then I would send them a personal property declaration and would expect them to declare everything necessary for that business, whether it's the furniture, the linens, that kind of thing.
So everyone has, excuse me, so everyone has to report the income, whether they're 6 units above or not? Or only the 6 units and above have to report the income?
Only the 6 units and above, or commercial, hotels, marinas, you know, all our commercial properties, multi-use properties. You know, if you have a commercial and a residential rental in one building, you would have to report both.
So
But
if-
for residential, it's only 6 units and above.
And so how are you on, how is one on that list other than by your sleuthing LLCs who buy property? I mean,
Which list?
the
Are you-
list of people who have to, to the short-term rental conversation,
For personal property?
if we're gonna have some increased assessed value on short-term rentals to
Mm-hmm.
match long-term rentals, because I believe now the Supreme Court says we have to treat them equally, how does one get on that list?
Well, our office is fairly diligent. We peruse all those listings out there, whether they're houses for sale or whether they're Verbo listings, Airbnb. We do look for that. The difficulty is if it's a home and they're using it for a number of months, then those are their personal belongings generally. So there's a little bit of, difficulty there. But any of the soaps and anything that they would provide that would be replenished, that would be personal property. But without a registration, it's my office doing research that sends out those declarations.
So I guess the dilemma we're having as a committee is how do we get people to register that they are using a short-term rental, number one?
That's
So
a
would we
problem.
just-
I would think that would be a problem. The way we get the people to fill out their income and expense statement is the state in their statute allows us to penalize 10%, which is a hefty penalty on real estate. It's a far different number than 25% on your personal property.
But if we're under 6 and unless it's a mixed use, then you don't have to.
Then you don't have to. That's
I'm
right.
wondering why
So you don't have to do
why
income and
I-
expense, but
Why I did that? Why I've reported it all over all these years on those.
Well, you haven't actually, and I've had conversations with your accountant saying, no, you
Right.
filed the wrong things, we don't need that.
back
This
to
is
the
what we
subject
need, but
of-
we don't need the other. Yeah. You filed for the wrong address.
can you just straighten out something for me? Because I hear
Sure.
you talk about it's got to be 6 or greater, and that means that you have to do which?
The income and expense.
Income and expense.
The income and
personal property
expense form.
could apply to somebody that has a single family, or
Yes.
still 6 and above.
Yes.
That's my
So
confusion.
personal
Okay.
property, anybody that conducts business in the town of East Lyme is liable for personal property tax and personal property filing. So, whether you're running a home business and you're, crocheting something, or you're a
Are
manufacturer,
you watching my house? I don't. Just a little crochet, not a lot.
Do you treat known short-term rentals different from known long-term rentals? If you're aware that either one is operating, is there a different rate, a different way to assess?
well, it would depend on if the house is furnished or not. If it's a long-term rental and it's not furnished,
Right.
then there's really no personal property involved.
Got it.
If it's academic rental, which would be a long-term rental, but still different than a yearly lease, then those people, we would send personal property declarations to. And when we find out that there's a case of a property that's it's owned by a business and they're advertising as short-term rentals, we send them a personal property declaration.
Got it.
And if they don't file, we use all those photos that they advertise, and we price everything out according to the photos that we see.
And I bet, do you have access to MLS to see what they're listed as?
Yep, but they're often not through the MLS, the short-term rentals. We go on the typical websites as if you wanted to go on vacation yourself. Yes.
I have a question on taxes, property real estate taxes. Say, for example, you have a company comes in and they buy a couple of houses in a beach neighborhood to use as a short-term rental, and they pay a lot of extra money for it because they're going to make an income. Now, would those houses that have a higher purchase price be used as comparables to determine property taxes on comparable neighbors' houses that are just used as a residence?
Well, in mass revaluation, first of all, we don't look at those sales, we don't do anything with those sales in between revaluations. So when it becomes time to be a revaluation, then we go out and we qualify all those sales. I mean, I shouldn't say we don't look at them. We look at every single sale and we qualify whether it's a valid sale, a qualified sale, or a not qualified sale. And if it's an outlier, we find out why it's an outlier. And, you know, we can kind of keep track of that. So when we come to revaluation, you know, we have a whole universe of sales. We're looking at everything within the town, so any statistical anomalies
I gotcha.
would stick out.
Right.
But we haven't seen that yet. I mean, we're seeing property values going up and up.
I don't know why.
You know, but they're going up and up. They have been, you know, since our last revaluation. But you know, we haven't seen a difference between those that are bought and then used as verbos versus those that are bought to be used as year-round homes or summer homes.
Thanks, Diane. Any other questions? We'll set. Yeah, well, thanks for the info.
Okay,
Yes,
thank you.
it's it was an important section in the report, you know, for sure. Thanks. And
Thank you.
you helped to clarify a lot of the weeds.
Thank you.
Thanks.
Thank you.
When we scheduled this meeting, a number of people said they wanted to leave by 8:45. I
Okay,
wasn't one.
that's fine. Yeah,
Is it right?
I think we're ready to,
Is it a football game or something like that?
yes.
Is it?
I do not want to belabor anything longer than necessary, but there were a couple things I said I'd get back to you on.
Oh, sure.
The sign regulation
Okay,
is
perfect.
section 18,
Yes.
point 1, point 11, point 1, point 3.
Okay.
Those are temporary signs that are not subject to, I believe they're not subject to regulation. And Mr. Ciccello, you had brought up section 20.3. That's under the general regulations, and it goes to define what a home occupation is and is not and what is required. And it does note that such uses as restaurants, tea rooms, funeral homes, barbershops, beauty parlors, tourist homes, and animal hospitals shall not be deemed to be a home occupation. So I don't think that translates to saying a tourist home, which is, I do believe, a vestigial definition from back when zoning was first enacted. I did some digging on another matter, and I came across tourist homes long ago. I don't think that means that even if we equate a tourist home to a short-term rental, that it is evidence that it's prohibited. I think it's just evidence that it cannot be considered a home occupation.
It was written a little weird, right?
Yeah.
Right.
Yeah. So that would be my comment on that. That's all I have. Thank you.
Thanks, Mark. Thank you. Okay, so, you know, I guess we need to digest a bit what we heard this evening, what we've read, go back and reread. And I was thinking, you know, and tell me what you think of this, at our next meeting individually we can start to think about potential final recommendations or recommendations to the Board of Selectmen that involve, let's say, zoning, ordinance, or both. So I'm just keeping all that open out there for the moment. So I could, you know, sort of like a little homework assignment for everyone to go back and think about if you could make some changes to zoning or not, you know, what would those be in light of what our town attorney, Mark Zamarka, has illuminated for us tonight. Thank you, Mark. And see where we're at. Same thing with an ordinance. Just so I kind of did the background on this public act, and there was I was looking for like legislative history, and there were comments. You can read those. I may just circulate those. People did testify in favor or not of that state statute, just so you have a little background on that. But what do you think, applying that, how would you apply it? So maybe just, individually, you can work by yourselves and just come up with, and then go back and look at the report. I suggest that because, we had recommendations independent of, the zoning and the ordinance, whether it was noise or parking. So look at those again. And I bring your attention to those fundamental questions, the fundamental questions we need to ask that we discussed tonight, and that process. If you're thinking about, don't forget, you have to think about enforcement. What would it look like? Very important. So let's have a first crack at it, kind of. Now that we've had this discussion tonight, which I thought was very helpful, because you read the opinion and you read the newspaper articles and your head's spinning a little bit. How does this apply? So we have something to go on. And meanwhile, if there's anything else that comes out, any other town, and I might just reestablish some connections that we've already made with some towns. If they're like the town of Preston doing some zoning, and working on their zoning ordinances, what are they thinking? So I don't want to get too laborious about it all in terms of, thinking about what other towns are doing, but if you've made connections and you can reestablish those and find out what's going on over there. You told me you're working on zoning. Well, what are you doing now in terms of, because this Whibby decision has come out, and that will be very helpful. So, yeah, and I think that's about it. Yeah, go ahead.
Greg's proposal.
Yes, and so, again, that's in the, I didn't specifically say this, thanks for bringing it up. Absolutely, so you look at Greg's suggestions, and, that's maybe your, that's sort of your parameters or something that you start with, or you incorporate some of his ideas, so for sure, yeah, that's very helpful. But a definite look at it all. Look at zoning, look at ordinance, look at both. If you've got questions, just write the questions down,
So are we've given the report to the selectmen
Yes.
with the one caveat that we're waiting for the Supreme Court decision?
Yes, and
Right.
any other development that happened, and we now
So
have
we have a
two
couple.
developments,
So-
yeah.
So now we have a couple developments. Are we gonna just say, here's our report, based on these two developments, this is the modification of or are we gonna start uncovering rocks again? And-
No, I don't feel the need to rewrite the report. I feel like an addendum with final recommendations would be appropriate, because this was pretty comprehensive about the world of short-term rentals
Yeah.
here,
My point.
et cetera, et cetera. And it's just kind of an update. It's an update. It was that status report, which is why we gave it that title. It was Gary's thinking there. That was the status as of April. Now we've gone over some big bridges here, and things have changed. And I'm glad we took the break, but I'm very glad we did the report when we did, because at least we've answered a number of questions and put together enough data and did the public hearings. And if we do another public hearing, which we should do, it would be based upon some kind of final recommendation, that set of recommendations that we have. So then you put that out to the public, and then we would come back and say, we'll modify a little. And at this point, not to worry that there isn't consensus. There may never be consensus totally with the group. I hope there is. We've had a lot of consensus so far, which has been very helpful. But it might be that we're going through a rocky period and we have to work it out. So just write what you think.
So you're looking for a summary of
Yeah.
our issues from each member?
Yeah, basically a summary of how, if you had to make, it doesn't have to be 10 recommendations, it could be your top 5. these are the ones I want, and I still have questions, can we do this, this, and this? And remember, if it were zoning changes, we're not gonna write those zoning regulations. We were just gonna recommend, you know, a certain type of change to zoning. If we're gonna, the same thing with an ordinance, you're not going to write the ordinance or worry about the, you know, you're not getting in the weeds. You're saying if I were to do an ordinance, it would have, such as Greg did, it would have A, B, C, D, and E.
So you're looking from each of us
Yes,
something along the lines
exactly.
of what Greg
Something
submitted.
like that, exactly. Yeah, it doesn't have to be elaborate, it doesn't have to go on for pages or anything like that. Just your first, like if you're, think of this as trying to solve this problem, you know, getting to resolution, and how would you do it?
So,
Okay,
we're just trying to get to the point where this last paragraph in your thoughts and conclusions, the committee looks forward to presenting its status report. We are also looking forward to finalizing our recommendations. So each of us think about what those recommendations
Yes,
might be
yeah,
for our homework.
yes.
Greg, thank you for doing the homework in advance of the rest of the team.
No problem, Ben.
Okay, you bet. Okay, thank you for doing that, Greg.
And then we
Seriously.
come up with now a, future meeting date, so would you?
can I ask one more question?
Yes, go
While
ahead.
Mark is here.
We have to-
In zoning,
Yes.
in,
What? Go ahead,
I
quick.
was saying one quick question. In zoning, if property becomes, you know, you're grandfathered in, but if a short-term rental home was to be, you know, for example, just do it in the winter, usually in commercial, a lot of times, I don't know what it is in East Lyme, but some towns, 6 months, a year, you lose that particular special permit or zoning or sometimes. So, you know, how would that affect this if we put a new regulation in a grandfathering?
A pre-existing non-conforming use has to be abandoned, and that's a matter of circumstance, but in general, you know, you're looking at a length of time where it wasn't used for that particular purpose. This would be considered a non-conforming use. So if it had not been used as a short-term rental for a long period of time, there's potentially an argument that the owner had abandoned that pre-existing non-conforming use.
But just the sale of the house would not,
No, not necessarily.
And not, usually there's no time period, like, and
No,
some,
the non-conforming use runs with the land.
okay.
Anything in terms of what would be considered abandonment, again, that's a fact-specific determination. There's no bright line.
Okay, thanks. So, future meeting date for this, for our discussion of our homework. In 2 weeks will bring us to September 9th. Is that okay? Or too soon? Or
Too soon.
too soon?
I think the 16th or 23rd might be better.
Okay. Yeah. Any overall preference? Do you want to say the 16th?
23rd looks good.
23rd looks good for you? Okay,
I might be able to make that.
okay.
Maybe.
So 23rd is better than 16 for you?
Absolutely.
Yes.
Okay, gotcha.
And so you would want our summaries then, you should give us a deadline.
Yeah, so I'd say, the 22nd. I'd say, you know, maybe, can we say the Friday before the meeting? Is that, I don't think that's too bad, right? So what is that?
So it just gives you the weekend to work on it?
Well, the weekend to read it, I mean,
For the rest of us to read it.
you know, let's say Thursday or Friday of the preceding week. You know, Friday at the latest, but try to get something in
Okay.
on that. That would be the 19th or 20th. And that just, you know, gives people a chance to read. Does that work out?
Yep.
Yeah.
Good.
Okay. All right. So any other comments? I think we're all set. Right? I think we're good. So I will take a motion to adjourn.
Motion to adjourn.
Second.
Thank you, thank you.
Thanks, and I'll.
I'll put that on what took place today.